Howdy, my name is Brian Foley. I'm a criminal defense lawyer here in Conroe, Texas, and I help people who've been accused of a crime either in Conroe, the Woodlands, Houston, that surrounding area. I do go all over the state depending on the crime, but I focus mainly in this area. And so today we're going to continue our lecture series on the Texas Rules of Evidence. Today's going to be a short lecture, as all these lectures are going to be, but today's going to be real short because we're talking about Rule 102. Which is really short in and of itself. It is not so much a rule as it is like a mission statement. It just basically says that the rules are supposed to be applied in a just manner. It's supposed to be, let me read it to you. These rules should be construed so as to administer every proceeding fairly, eliminate unjustifiable expense and delay, and promote the development of evidence law. That's a good one. When is the last time you were in a trial and you felt like, oh, I'm gonna make this objection so that we can promote the development of evidence law? No, this is very rarely happening. This rule is just there so that you can have an extra bootstrap argument on an argument that almost worked, right? You've made your argument to the judge. This is hearsay. It should not come in. It's being used to prove the truth of the matter asserted, and it's detrimental to my case. And the judge is like almost going to rule with you, but maybe doesn't want to. You can say, well, Judge, again, I would also argue under Rule 102, it should be administered in a fair way, and it should be to get a just determination. Those are like really touchy-feely arguments. They're not likely to work with a judge. I guess today the best advice I can give you for talking about Rule 102 is don't ever make this argument as your sole argument. If this is your only argument, you are going to lose, okay? This rule is just here because the people who make rules, they like to have these aspirational statements at the beginning of the rules. One thing I would say, when you're talking with a judge, the judge is almost always concerned with what the law is. They are never going to care about what your feelings are, right? So you never want to argue to a judge like, well, I feel that this is hearsay because, well, no one cares how you feel, right? You would say, this is hearsay because. It's not about your feeling about it. You're arguing what the law says and is. And so if you're making an argument to a judge, you ever find yourself talking about your feelings, cut them out and stick to the law. You're going to get in a much better spot for you and your client. I hope you enjoyed today's lecture on Rule 102. And I doubt you will find it very helpful, but at least you know, like, this is one, don't worry about it. If you're studying for the bar exam or you're studying for the board certification exam, I doubt Rule 102 is going to be on there.